Are you here in
Yes,
this
Your
one? We now call cause number 23 CR 1439, the state of Texas versus John Walter Bordash Jr. The defendant is present with Mr. West, John West, his attorney, and the state's attorney.
Okay. This is a follow-up. This is an update. I previously did a video on this guy. Link in the description. And then Zach found this today and gave it to me. Big shout out to Zach. Go check out his channel. Law Nerds Unite. Thank you, Zach.
We are picking up a matter as soon as we have gotten the information concerning the matter of competency concerning the defendant. A motion suggesting incompetency and request for examination was filed on in October of 2024 by the defense, and we had some matters taken up in the meantime concerning the defendant's placement on bond. This indictment of the defendant was handed up by the grand jury on September 20th of 2023 and has been pending. And we've had some matters over the course of that time concerning defendant's bond and whether his bond should continue based upon circumstances that were brought to the court's attention. Then the defendant was placed on bond, and then later his bond was revoked by this court upon a hearing determining that the bond conditions were not being met properly by the defendant. A motion suggesting incompetency and request for examination was filed again in October of 2024. The court ordered Dr. Ed Grappon, licensed psychiatrist, to conduct an analysis and evaluation.
Oh, they sure did. He stopped the proceeding. You got to see the last video. Link in the description. He stopped the proceedings and made the attorneys figure out a time right then and there.
Of the defendant. That was done. We have received Dr. Grappon's report dated February 3rd of 2024. And the court
One sentence. The cheese is off the cracker.
Has given copies of this to the state and to the defense. I am, for this particular hearing, calling this and marking it court's exhibit number 1 on today's date, February 6th, 2025. In this cause number, it will be made a part of the record for proper purposes on any issues involving this particular matter. Any objection by the parties?
No
State and defense?
No objection.
No objection. It is made a part of the record and it will be sealed. And only information will only be disclosed to the necessary parties, that would be people who are treating the defendant, or for the parties as necessary for legal matters that may arise in this case. So, in summary, upon evaluation, Dr. Grappon's report includes information about Dr. Ed Grappon, where Dr. Grappon is a licensed psychiatrist. This court is well informed of. I believe I first met Dr. Grappon when he was brought into.
There's no navel gazing, nor is there any pearl clutching here at Law Talk with Mike.
the James Byrd murder cases that this judge was part of the prosecution of in 1998, and Dr. Rapon analyzed defendants and testified during that trial for issues that came about during the sentencing of the defendants. So the court has known him since 1998 and known Dr. Rapon to be a highly qualified man and has his medical doctorate in psychiatry and has evaluated countless individuals in his civil practice and in criminal cases here in these courts in Jefferson County for decades. And his reputation is pristine on his abilities and his competency in doing his job. He has prepared a 5-page report after evaluating Dr. Bordash at the request of this court, after this court found good cause to have Dr. Bordash.
Oh, yeah, they did. They found great cause.
Evaluated. And it has been made a part of this record as Court's Exhibit 1 for this hearing and any other purposes that are relevant to the defendant's competency. And within the report, the doctor details his interaction in his speaking with the defendant, and is quite apparent in his words that Dr. Bordash demonstrates significant paranoia, particularly in regard to the legal system. His judgment is impaired. His insight is almost nil. He is diagnosed by Dr. Rapon with delusional disorder, non-bizarre. As to competency, the defendant is not competent at this time to proceed to a resolution of his legal issues. He does not possess in his current state the ability to communicate with his attorney with a reasonable degree of rational understanding in the preparation of any defense. The defendant is mentally ill by definition. He would require involuntary psychiatric treatment intervention for restoration of competency. He has no insight into his condition and adamantly believes he is being victimized by this situation and the legal proceedings surrounding it. It is very unlikely that he will accept that he is operating under a totally false belief system. He states repeatedly he is the victim of electronic harassment perpetrated by his neighbors. And when asked about any of his legal difficulty, according to Dr. Rapon, the defendant gives a very paranoid and/or delusional explanation for the total scenario. All right, then the final determination is that the defendant is mentally ill, is incompetent, and needs a hospital treatment, inpatient treatment at a proper facility of the state, with our hope of him gaining competency to stand trial in this case. Anything the state wants to add to this report?
No, Your Honor.
What about the defense?
I do not, Your Honor. However, my client has reviewed this report and does not agree with the report.
Okay.
And didn't want to address the court. But I will stand by the report. I'm the one that requested the competency in the first place, so I don't believe it's competent. So I believe the doctor's suggestion is correct, but my client does want to address the court.
Okay. Is that right, Dr. Bordash? You want to make a statement?
Yes.
Raise your right hand. Do you solemnly swear or affirm any statement you make will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
All right, lower your hand. I think you marked, I gave Mr. West a copy of this. You marked on that document. It's a duplicate. It's a duplicate of a true and accurate copy of what the court received from Dr. Edgar Pond, and I marked that as court's exhibit number one that you referred to and make notes. I didn't read your notes, but you can refer to those as necessary if you wish, and that's for you and your attorney to have. Go ahead. What would you like to add, sir?
Oh, well, Dr. Papon says I performed a standard psychiatric interview with the formulation of a formal mental status exam. No, he did not. I was not given the mini mental status exam, MMSE, and the Montreal Cognitive Assessment, also called the MOCA for short. And page 2, I guess he, third sentence from the bottom. It says he denies a history of mental health treatment, but has for a number of years been under the care of local psychiatrists for a diagnosis of narcolepsy, for which he takes Adderall on a daily basis. Actually, I acknowledge a history of mental health treatment for neurocognitive issues, for example, attention, concentration, processing speed, and motivation. And let's see. And has been for a number of years under the care of a local psychiatrist and some in Houston for diagnosis of HIV-associated neurocognitive disorder and narcolepsy, for which I take Adderall on a daily basis. But it also helps with trigeminal neuropathy. Second, the next sentence, he does report that he has had essentially annual neuropsychological evaluations done over the past 10 years because of concerns about cognitive issues. That is true. However, it is because that I've been conscientious of ethics issues pertaining to competency for a long time because of my condition. And I have volunteered to undergo neuropsychological evaluations on an annual basis to confirm that I can continue to work on a part-time basis. For this reason, I've been showing conscientious. I've been very conscientious about the ethical issues of competency. And I have been having Dr. Mario DeLay, Methodist Hospital in Houston, in the medical center, conduct these evaluations since 2011. Next page. Dr. Grapon says he reported that the date of his next examination was due to be at the end of January 2025. Yes. And a neurology consult was also set up by me for January 20th, 2025 at 3 p.m. with Dr. Mary Bowe, B.O., M.D. Let's see. The sixth sentence down. Apparently, this involves some interactions between he and the neighbor, which he seems to have generated by his delusional belief that they are somehow adversely affecting him through electromagnetic waves. Now, my response is, whereas I acknowledge that in the past, patients were at one time considered delusional when they made these kinds of remarks, recent research over the past 10 to 15 years would suggest that there is some scientific validity to these claims. And certainly the World Health Organization has adopted electromagnetic hypersensitivity syndrome as part of the ICD-10 diagnostic code book. The next one is, let's see. where it says affect is generally appropriate, although he has a number of somewhat paranoid ideas in regards to the legal system, the reason for he is in current legal difficulty, et cetera, et cetera, et cetera. Actually, no, I have reservations, not paranoid ideas. And the next one is he has a fixed delusional system in regard to what he feels are health-related problems that he is having because he is absolutely convinced that his neighbors are poisoning with microwaves from their home, from their home to his residence. No, I'm able to distinguish when symptoms of microwaving are occurring and when they are not, and to discriminate between who is most likely to engage in such deadly conduct. The next one is, he basically told me that he has had some type of device which would read the strength of these electronic impulses, and he could determine that they were coming from the neighbor's residence. It's really kind of well, not specific enough. Actually, on any kind of cell phone device, you can download applications that are written specifically to detect electromagnetic waves and their strength. Actually, you can see on any cell phone that there's a antenna icon with that gauges the strength of the signal that you're receiving. And so that's the same sensor that is being used by these applications. The one I was using is called gauze meter. Gauze is a measure of the strength of a magnetic field. And it can also be measured using units called Teslas or microteslas. And these applications, the one I ended up using more than the other was gauze meter, because I can take constant readings up to 300 seconds intervals and locate where hot spots were being found in my home. The first one was in the right bracket of my shower.
Hotspots in the home.
Sometimes the readings would be as high as 5,000 microteslas or higher. And then on the shower wall that separated the jacuzzi, those readings would go down to maybe 3,800 microteslas. Past that is my master bedroom closet.
Oh, good Lord. It sounds like a black light search here.
In line with the shower wall bracket, readings could go down to about 25 microteslas. And then in the garage, about 10 feet from the garage door itself, which is still in line with the shower, the readings would go down to about 2,000 microteslas. Now, the progressive decline in strength of magnetic fields would indicate that it's coming from the direction of my neighbors. They have never had a white tint put up in their backyard before, until I started having these experiences. And so they are coming from that direction.
A white tint? What the hell is he on about? I can't even follow it.
I've also determined that at times the whatever device is in that tent is sometimes shifted, and I pick up high readings around between my bedroom window and where I lay my head on my bed. Since then, I have put in a door glass, a pane of door glass from a previous office, because glass is used as an insulator for magnetic fields, electromagnetic fields. And that was enough to reduce the signal strength from about 2,800 microteslas down to about 700. So about a 75% decrease in these strengths. I've also put jugs of water to try to absorb the rest of the microwaving. However, that proved to be a kind of messy because by morning time, the jugs had expanded because of heating and leaked onto my.
But allow me to interrupt, just please. I think I understand. You are in more detail, but repeating what you had earlier toward the court before.
Oh, good Lord. This is the second time through this story. Oh, shit. I mean, I'm not buying any of this, but why don't you try something like a Faraday cage? Like that would actually do something. Like, I'm not buying it, but like why wouldn't you go to something useful?
In previous hearings on this matter. Let me ask you what you've never articulated to this court clearly is why would your neighbors do such a thing that you think they're doing to intentionally cause you harm by this surreptitious.
You feeling in for Andrew, Katie?
No, hold on. Microwave attack on your mind.
Okay, not on my mind.
Why?
My person.
Why would they do that? What do you think the motive would be if this is true?
Well, it could be religious objections to my sexual orientation and the fact that I was in an interracial relationship. I mean, years ago we had.
Okay, you think that might be it?
That might.
I want to say I know I have issues, but I have good intentions.
Be it, amongst other things. The fact that I suspended fees because Miss Payton showed up at my door making ridiculous claims that I should pay my fees because we needed to replace the street. That street won't be needing to be replaced for another 75 years. So I don't think
Are you talking about homeowner fees?
Yes. I don't think we should be taking up, paying fees when neither one of us is going to be alive when that street needs to be replaced.
What else do you think? What else?
And the fact that, whenever we had a homeowners association, which I have not been invited to for ever since Mr. Warren and Esther Yates moved into my home, a gentleman of color with whom I had a relationship for about 25 years and lost him to a number of factors that were
Is there any
terribly heartbreaking?
Okay.
How dare you? I did a reaction to video to every episode.
Otherwise,
anyway, we used to have lawn care service that was provided by a black-owned a company. Okay, and they did a good job. That all changed when because Miss Payton and Mr. Payton are very prejudiced individuals.
Okay.
They had a robust gentleman from LaBelle, by the name of Kane, provide yard care service.
Kenny.
Until I raised the issue with the fact that he kept raising fuel cost. But when I looked at a graph provided with about the cost of fuel over a 10-year period, it was pretty much no, it was erratic. But it was
you've made. I think I understand your point. Is there anything else you want to add?
With regards to Dr. Rapon's report?
Yes, sir.
Okay, yes.
This is the focus of where we are.
Keep going. let's see. He will admit there is no medical provider who has supported his opinion, and that that is the basis of his alleged medical problems. Actually, I would rewrite that as he will admit that there is no medical provider who has validated his hypothesis that is about symptoms that have experienced that are specific to electromagnetic hypersensitive. Hypersensitive syndrome. I understand the need for independent third-party validation to my claims. Okay. And then the next sentence,
I
apparently.
know what he's saying. I've read it on numerous sites. It's in the record. We're taking time up just repeating what's been said. I just want to know what you want to add that's not duplicative of what he has already stated.
Well, I've had a Latino tile worker notice a difference in the EMF readings I was getting on my cell phone after he removed a mesh work that was under the jacuzzi bench.
I want to dumber down the ticket. I want to fight that.
Okay, so he's seen that for himself. I acknowledge myself that in the past others have been described as delusional, but I possess the research skills to use appropriately designed applications to measure.
Oh, wait. I want to let that sink in. I know that in the past I've been described as delusional. Also in the present.
Electromagnetic flux in the environment, take repeated measures that are reliable and concentrated in areas of my home, and to determine the direction of the source by the strength of the signals. I don't know if his wife is directly involved. I think it's more Mr. Payton and their yard man. They feed into one another. And certainly the yard man feeds into Miss Payton, particularly while.
Oh, there's definitely a Karen behind all of this.
Mr. Payton is not around.
Okay. You've expressed that some times before. What else, sir? We need to conclude this hearing and move forward.
I'm able to, okay. And I would not say so much that they are producing some type of electronic signal that is causing me various symptoms. They're generating these microwaves that are inducing symptoms separate from symptoms associated with HIV-associated neurocognitive disorder. So I'm able to distinguish that there is two issues. Let's see, by a process of reasoning called convergent validity. Okay.
What else?
Also, that these experiences are not present when I'm in other locales because of a lack of exposure to electromagnetic flux. Okay. So I do not think my judgment is impaired. However, a person exposed to these inductions can be under a great deal of emotional stress, such that, one might be desperate to stop them. I'm not keen on reacting or responding to any aggression that is shown towards me. Instead, I think of ways to arrest them so that people just expend their energies for nothing at all. They're not reinforced for them, and I'm not faulted for responding to them. And one of the ways is that I bought 20 to 40 yards of Faraday fabric, which is fabric infused with copper and nickel particles that reduce the entry or the strength of electromagnetic waves into my home. And they have been exceedingly successful in doing so.
You've made that point. We'll conclude, please. Thank you.
Okay. I would take issue that that I can't provide a rationale for my experiences that can be validated independently, and that I do not. I'm not mentally ill in the sense that I have an emotional or affective disorder, but rather I have neurocognitive deficits that are consistent with the dopaminergic reward system in the brain and its purpose, okay? I am willing to accept voluntary psychiatric admission to Methodist Hospital under the care of Dr. Vo and Dr. DeLay. I do have insight into my condition. In fact, because a PhD teaches MDs, I often educate them about my condition, and I can provide research reports to back up my opinions. So I suppose that's by and large everything I could
Okay.
add.
All right.
Oh, sweet Jesus. What?
The court, and what you are telling this court, do you stand by its accuracy, the accuracy of what you have told this court under oath?
Yes.
No. And is this the same accuracy that you have used in the interactions with this court in the past when you speak to the court or make statements to the court? Is it that same accuracy that you have used in the past?
Yes.
Okay.
Yes.
I think that's where we're headed here, Captain Colombo. He clearly needs help. It's going to take a case like this to do it. So I don't know how it ends here, but he just said he'll go voluntarily to some people, but I don't know if those people are quacks. He's going voluntarily or involuntarily is my guess.
All right. I'm going to remind you, you remember I think one of our first meetings, you called me a drunkard. And we all heard that. And that I had a reputation of being a drunkard when I don't drink alcohol. Do you remember that?
Well,
Do you remember that?
yes,
the
I remember
point is
Yes,
that-
and there was some basis for
Well, welcome to my world, Judge. I get that every day.
me saying that.
There was, God bless you.
Yes.
Well,
Yes.
were you mistaking me for somebody else?
No.
Oh, okay. Well, okay.
Judge, you don't understand. He knows your drinking habits better than you. Huh? Did you ever think of that?
Everybody,
You
this
were-
whole town.
you were identified as attending a
This
meal?
court does not drink alcohol.
Okay.
And, that's
Okay.
I'm a soft
Well,
drinker, and
I
that's
was
the way I
informed by a
am.
gentleman that whom I had no reason to question his validity
All right.
since he worked as a waiter there at my restaurant.
All right. This court doesn't purchase alcohol from
I do like a good claw on occasion, but I mean on occasion.
businesses.
And there was also an alternative
restaurants. I don't,
hypothesis.
but that's
Because of your
that's
tremors.
that's the first time I've ever heard that one. But in this job, this court is not surprised of what can be said, but it's what is supported.
Well, have you taken medication before? Are you
Sir?
taking medication now for your tremors?
Oh, my familial tremors,
Yes.
which you see, that's another thing.
Are you
These
taking
are this is, you have misdiagnosed this as well. Yes, everybody knows that this court has what's called familial tremors. I got it from my mother. My mother had it, and so it was passed on.
I
But
understand.
I also have am an artist. I'm able to control those, and no, I don't even take medicine for it. I've only had it my whole life, and it has not affected anything
Oh, good Lord. We're hearing from the artist formerly known as Judge Stevens now.
to do with my ability to think, function, and that's, you and I are completely different, sir. This is apples and oranges, what we're talking about. And this court there's been never been a question about this court's competency, nor a question of this court's ability to conduct myself physically. And I actually still run in the 10K whenever I can. I think it's pretty good. And I played sports, but I think if you of all people shouldn't be making conclusions when you don't have the basis of it. And if you know anything about familial tremors, you know it has nothing to do with competency and incompetency, and it is one of those situations that's traceable. That is of all human qualities one of the least problematic of all. You are the function of, you are the focus of this.
There are
You
some
and your
conditions
actions,
in which
you
people
have,
are not
I'm sorry,
aware
sir,
that
you
they are
interrupt,
having problems.
you interrupt, and we can't both speak when this court reporter is taking down. I've really had to scold people in the past, but I shouldn't be scolding somebody like you, except I've come to know enough hearings that you want to control every hearing. You want it on your terms. And the fact of the matter is, you were indicted by a grand jury. You have had hearings here where this court allowed you to post bond, and then you violated your bond conditions. And then the statements you have made, not only at this court about alcohol abuse, God, my goodness, everybody knows differently, and then you attribute that as familial tremors caused by alcohol inducement. That's bizarre. You know it, and I know it. You just don't have the basis of connecting that a physician should have in any education that you have had up to this point on making a diagnosis of bizarre terms like you have made. But the point is when you're here, you say things that roll the eyes of everyone. You accused your neighbors of attempting to harm, deliberately trying to harm you by using microwave energy with little or no basis.
I'll go with no basis. It is interesting how much that got under the judge's skin. I understand it because he puts up with a lot and usually ignores it all, but that got under his skin. I mean, it is hard to take. This guy lives in a glass house. He, of all people, is going to start throwing diagnoses around about other people. Okay.
The rules of law will apply, as they should in all cases here. Chapter 46B of the Texas Code of Criminal Procedure deals with incompetency to stand trial. Under 46B.004, the issue of competency to stand trial was raised, and it was suggested by your attorney on your behalf. The court ordered an analysis to be made by a competent physician, doctor of psychiatrist, Dr. Ed Rapine. He was an expert under 46B.022 who examined you, filed his report under Article 46B.025, and his report states that you are incompetent to stand trial and proceed to a resolution of your legal issues, that you are mentally ill. And from testimony of the neighbors, they fear for their safety because of the actions you have taken in your bizarre response to your theory that the neighbors are conspiring to harm you with electromagnetic energy.
Yep. I bet that gets annoying as hell.
Law places the burden of the trial court to conduct the informal inquiry that this court has done, and that resulted in the ordering of the examination on competency. Some evidence standard is met, and this to proceed to the competency issue, there is a bona fide doubt standard for determining whether there should be an inquiry that this court reasoned was valid. and that the court may make an initial determination of your competency to determine whether examination should be made not only based upon the court's own observations, but other information the court may receive in its hearings, and may make a determination on competency based not only on the court's own observations, uh, uh, but also with a psychiatrist report as been submitted in this case. Thus, the issue of competency is before this court, and this court deems that the evidence supports fully that the defendant is incompetent to stand trial and is unlikely to be restored to competency in the foreseeable future, based upon the information from previous hearings, and then most importantly, the evidence submitted from Court's Exhibit Number 1, admitted without objection, Dr. Edward Pond's report, and the other statements, bizarre statements that are being expressed by this defendant. So, Dr. Bordash, the court will deem you at this time to be medically deemed incompetent. We are going to transfer you to the proper state medical facility, where treatment will be made for you, and that you will hopefully cooperate in that treatment. And our whole hope is that one day soon, hopefully, that competency will be restored to you. And this court
We hope you are restored to competence so we can put you in jail.
will sign the appropriate orders to ensure that that shall be accomplished. Anything else to be added by the state?
No, Your Honor.
Added by the defense? No. All right, we are in recess on this. That is all. Here's this.
Wow, that was. I think he's off, but thanks again to Zach. That was more interesting than I thought it was going to be.
We're in recess, and we will be getting back into this murder trial shortly. Thank you.
It's not an easy gig. You go from tinfoil hat wearing guy to a murder trial. And that's what they call Thursday. That's interesting. Do I have any professionals in the, like, what are the chances of this guy being restored? I have no idea. If anyone knows, let me know. Is this condition treatable? I don't know what the condition is. I kind of knew the situation. I knew that he talked. I'm like, okay, he's not competent. They sent for a report. The doctor comes back 0. we're not looking good at we're not optimistic on the restoration here. Okay, but we go in the beginning. I knew that he talked because I just spot checked it. Otherwise, I wasn't gonna stream it. And then in the beginning, he goes through the whole rigmarole. All right, we sent him to our doctor. The doctor says he's not competent, and I'm like, how in the hell is this guy talking then? But it was because he wanted to dispute the report. And I think as a matter of due process, that makes sense. His attorney says that's an odd scenario, but I think he played it right. It's an odd spot for that attorney to be in. But his attorney comes out and says, look, my client wants to dispute this. I don't. As his counsel, I don't think he's competent. Straight up. On the record. That's what he says. And the judge says, all right, which actually makes sense because there's due process. Like, I don't know. Okay, so maybe the fix is in and your attorney's not looking out for your interests, whatever. Here's your day. We're about ready to send you involuntarily for treatment. If you want to make your case on the record open so that people can see what it is and judge for themselves, go ahead. So he does. With the exact result we all thought, which is like, yeah, this is really, really confirming the conclusion that the doctor came to when he evaluated you. But I can't, it never even occurred to me because I've never been down this particular road. I've had competency issues in cases before, but never typically the way that works is you open an estate and you get somebody named their guardian for the person so that you can carry on with whatever legal business you were doing. In the context of my practice, that's what happens. So if someone's not making sense, all of a sudden you got to go, okay, we need to open the estate and appoint a guardian. And then the guardian can make decisions for them. You'll do that with minors or with people with diminished mental capacity, often elderly, but not always. It happens. I do injury work, so it happens with brain injuries all the time. But the law, this sort of stuff happens. Like that, we're not shocked by these variations. You know, humans are frail, and we have thousands of years of cases at this point. Not exactly in the same form, but literally an evolution of laws starting very early. And these things have come up since the beginning of time, and we've come up with solutions. I don't know if they're solutions, approaches to deal with them because it's sufficiently common that it has to exist. And a guy's been practicing for almost 30 years. At the beginning of this hearing, I'm still scratching my head thinking, okay, this guy's not competent. How in the hell is he allowed to speak at this hearing? And then I watch it play out and I think, oh, that makes sense. That's his one shot to dispute it. His attorney doesn't want to, says so openly. I think he's correct. The attorney's ethical obligation is to zealously represent his client. And in that circumstance, zealous representation does not mean indulging their BS. It means what is the best thing for this person in the circumstance that we're in. Okay, that's not like the definition. That's the La Tech with Mike version of it. But that's what it means. I don't know. I don't know what it is. If you look it up, it'll say something fancier than that, but that's what it means. Anyway, all right, I digress. I really got on my soapbox here. I don't know about what. I just found it interesting. I just found this one interesting. And as usual, a preemptive shut your pie hole to all the pearl clutchers. I'm aware that mental health is involved. And like adults, we watched it anyway. That's what happened. I'm not sorry. Thank y'all for coming out. I'll see y'all soon.